that as a matter of law, we have a legal system that regulates speech, and I think that it is fair, robust, and I would have no hesitation.
Let me put it this way, Counselor.
Yes.
You're sending an awful...
He asks 4 federal judge nominees whether they've heard of Section 230. 2 haven't. He asks whether a cop can shoot someone in the back just because he can't catch them on foot. Nobody will answer. Welcome to American hearings. Kennedy's rapid-fire judicial session is one of the most entertaining and substantively revealing confirmation exchanges on record. The Tucko line lands in the middle of all of it.
Thank you. Senator Kennedy.
Thank you, Mr. Chairman. Are any of you going to be dependent upon President Trump or any president as a federal district court judge?
No, Senator.
No, Senator.
Okay. Or before you render a decision, are any of you going to pick up the phone and call the President of the United States and ask him or her how you ought to rule?
No, Senator.
No, Senator.
No, Senator.
Okay. All right. Mr. Martin, tell me about Section 230 of the Communications Decency Act and the Internet, social media.
Senator, I have not come across Section 230 of the Communications Act during the course of my career as a prosecutor. I can't comment on it.
Well, as your career as a human being, you haven't heard any references to Section 230 and immunity for members for social media companies?
No, sir, I have not.
Okay. All right. How about you, Mr. Pozos? Am I saying that right?
You are, Senator.
How about you, sir?
Senator, my understanding generally, while I haven't practiced in this area, is that it affords a level of protection to Internet service providers that publish content of other parties.
It says if I post on Facebook and I defame somebody, Facebook is not at fault, right?
Senator, I have a very rough understanding, which is consistent with what you've expressed.
Is that a yes?
Yes, Senator, subject to the caveat that I'm certainly not an expert in the area.
Well, what if, and that seems fair to you, doesn't it? I mean, thousands, hundreds of thousands, a million, millions, squillions of people post on Facebook and they offer their opinion, right?
Senator, I think that the approach that was...
I'm not trying to trick you, Counselor.
No, Senator, I'm trying to articulate that my understanding is that when Congress enacted that provision of the law, it was trying to balance the interests of fostering speech through the Internet with the potentially chilling effect of liability. I understand, Senator, that there is a debate ongoing about the appropriate scope of those.
Counselor, I love you, man, like a taco, but you're using up all my time here. Do you think 230 makes sense to you?
Senator, I think that it is an approach that could be rationally achieved by Congress, and Congress could, if it chose to take a different approach, likely do so as well.
Do you think it was a good idea?
Senator, I think that as a matter of law, we have a legal system that regulates speech, and I think that it is fair, robust, and I would have no hesitation.
Let me put it this way, Counselor.
Yes.
You're sounding an awful lot like a lawyer. It seems to me it's fair to say Facebook can't be responsible for the content of what all the people who use it post. Okay? Fair? I'm willing to say it is. But does it make a difference if Facebook picks and chooses what I see? Doesn't that seem like putting your thumb on the scale?
It would certainly be favorable, it would seem, Senator, yes.
What does that mean?
It would afford additional protection beyond what may exist at law independently. For example, Senator, if somebody is curating speech.
Counselor, I have no idea what you're talking about. No offense. You're better off here just answering the questions. You really are. Ms. Mitchell, tell me about the qualified immunity doctrine.
The qualified immunity doctrine is one that protects officers who are in executing their duties are reasonable or have a reasonable basis for the actions that they're taken, and it typically is something that courts decide at the outset to protect those officers from liability.
Okay. So if a cop, if somebody runs from a cop, and the cop doesn't feel threatened, he just can't, he doesn't think he can catch the guy, and he shoots him in the back. Is he immune from liability?
Senator, I'd like to engage on this hypothetical, but because it's a fact pattern that may come before me if I'm confirmed.
Oh, come on, counselor. If I'm a cop and I'm talking to a suspect, and he turns and rabbits on me, and I say, I don't think I can catch this guy, but I know how to stop him, and I shoot him in the back. Are you telling me I'm immune as a cop from liability?
What I can tell you is the legal test, Senator, for qualified immunity, which is whether there was an objective basis.
Does it apply in a criminal case?
It's
Apply in a criminal case, does it?
No, Senator, these are typically in 1983 actions.
So I can't shoot him in the back, right?
Again, I don't want to comment on a specific fact pattern. I principally have practiced in civil law and haven't encountered that specific fact pattern, but I would look at the developed body of precedent on qualified immunity and ask the question that I understand the Supreme Court has settled about whether there is an objective basis for the officer's actions.
Yeah, okay. I get what. Look, you're smart. I've read your resume. I just caution y'all when you go back to your friends at the White House who've gotten you ready for these hearings. Don't dodge the questions. Just answer them. Okay, if you don't know, just say I don't know. I just think you're very qualified, counselor, but I can't believe you dodge on the question. Can a cop shoot somebody in the back who's running away just because he doesn't think he can catch him on foot? But anyway, I'm over. Thanks, Mr. Chairman. You're a rock star.
Thank you, Senator Kennedy.
Some days.
And I appreciate you're not asking the Texas nominees about the rule against perpetuities. I'm waiting
You
for
got
someone
it.
to get
We
there.
were going to get to that. I ran out of time.
Senator Durbin.
Welcome back to American Hearings. Kennedy opens by establishing independence. None of these nominees will be calling the president before they rule, and none of them are here to carry anyone's political agenda. That baseline gets confirmed quickly, and Kennedy moves to the substance. Section 230 is the first test. One nominee hasn't encountered it in his prosecutorial career. Another has a rough understanding. Kennedy works through the basic logic. Facebook isn't responsible for what its users post, which seems fair at scale, and then pivots to the more complicated question: what if Facebook isn't just hosting content, but actively curating what you see? Doesn't the platform's thumb on the scale change the liability analysis? The "I love you like a taco" line arrives when a nominee starts explaining things in language that Kennedy describes as lawyerly. It's funny, and it's also a genuine instruction: just answer the question directly. The humor is doing accountability work. The qualified immunity hypothetical is the sharpest section. A suspect runs. The officer can't catch him. The officer shoots him in the back. Is the officer immune from liability? None of the nominees will directly say no, even though the legal answer, in most jurisdictions, is clearly no. Kennedy's closing advice is his most direct. When you go back to the White House and tell them how to prepare for these hearings, tell them to stop dodging. Just answer. If you don't know, say you don't know. That's also an answer. Subscribe to American Hearings.